It's only 2.5 pages long. It's a tiny little bill. But for a 2.5 page bill, radically redraws the lines of internet regulation around the world. I mean, if Congress enacts this, it's going to change how 5.5 to 6 billion internet users around the world can use American infrastructure and speak freely. So for something very, very small, it would, if enacted, have some extremely significant consequences.
That was Preston Byrne. He's the managing partner of Byrne Storm, and he's been instrumental in the work that went into the GRANITE Act, the act that he was referring to that was introduced to the House only a few days ago. It's an important bill that can set the lines on the future of jurisdiction in the internet age, as well as free speech.
I've been doing a lot of this myself, like with my co-counsel, Ron Coleman, from Coleman Law. So we've kind of been doing this, at least on the UK front, we've handled all of the contested enforcements in the United States for American targets. So we're very familiar with this issue. I've been working on it for 10 years. Ron's been active in this space for a long time as well. He's he's a Supreme Court litigator. He was counsel in the Supreme Court case, Mattel versus Tam, which is a big First Amendment precedent on hate speech. So like we've been very, very close to this issue, as well as a handful of others.
This, I believe, is the first podcast he's done since the bill was introduced at the federal level. There are other bills in the state level. And in this conversation, we dive into the history here, why it's needed, and how sovereign immunity works in the US. And thank you to the sponsors of this podcast, including the presenting sponsor, Altitude, which is a stablecoin payments platform. If you do business in stablecoins or you have entities in different jurisdictions elsewhere in the world, you should probably learn about Altitude. Visit altitude.xyz/law to learn more. This is my conversation with Preston about the GRANITE Act.
So the traditional way that the First Amendment has worked and that First Amendment practitioners have worked is that the American government is limited in terms of the kind of content and speech that it can regulate by virtue of the First Amendment. Sometimes it oversteps its boundaries. And so what you do is you go to a court to vindicate those rights, and the court has the power to restrain the United States. The internet presents an interesting problem in that the internet is a global system, and foreign governments are currently using the internet to transmit threats into the United States in order to control how the internet is used in the United States. So it's a strange situation that we have where countries like the member states of the European Union or the United Kingdom or Australia have gotten into the habit of saying that just because a web server is visible in their country, right, even if that web server is wholly and exclusively based and operated in the United States, that web server, which is physically located in the US, must obey some foreign edict. And we don't think that's right. So the question is, how can you design a system within American domestic law, which allows Americans using purely American domestic levers to deter these foreign censorship threats from entering the United States? And this is something that I developed over 10 years, frankly, of watching how foreign censors try to censor Americans. And this bill very much implements, all of those learnings.
And history in your blog post plays a big role in just how you've thought about it and how really the doctrines that the GRANITE Act covers have developed. Can you talk about the unfixed structural flaw that you reference when it comes to the American system and how the thinking has evolved in this space?
Sure. So the problem is American law was written in an era when the internet did not exist and was not, could not even have been conceived. So the case you're referring to is the Schooner Exchange. It's from the early 1800s. And in that case, a French warship docked in the Philadelphia harbor to escape bad weather. And some bailiffs attempted to attach that warship for the payment of debts. And so that went all the way up to the Supreme Court. And the Supreme Court said, listen, there are ancient dignities of the sovereign, right? These are old English law rules. There's a rule called the revenue rule, which says that courts don't sit in judgment, over other sovereigns or collect their taxes, which dates back to 1712 that we follow in the United States. So it predates the existence of the United States, and it's an English rule. So under our system, traditionally, sovereigns don't try to regulate other sovereigns, right? So, and when they are present lawfully in your country, the ambassador, the diplomat, the warship, they are immune from the jurisdiction of your courts with respect to certain sovereign activities. Now, there are some exceptions where that changes. So if, for example, you indicate, right, through some type of action that you submit to the jurisdiction of the foreign country, if you commit a tort, which is wholly and exclusively committed in the United States, if you enter into a commercial contract in the United States, if you employ an American citizen in the United States, then what will happen is you lose that immunity with respect to that activity, right? So they can sue you, they can bring an action, the courts will have jurisdiction for those sorts of limited activities. But generally speaking, regulatory actions that are taken abroad, police actions that are taken abroad. There are cases from Saudi Arabia, right, where people get thrown in jail and beaten and treated very badly. And they'll try to bring an action in the United States over it. And the U.S. will say, listen, that's Saudi Arabia's sovereign business. That's not our American business to tell them how they run their affairs in their own country. The problem, of course, is that what's happening now is that foreign governments are transmitting threats by wire into American homes and living rooms. This is my house, right? And so every demand that I've seen from a foreign regulator, do this, do that, you have to obey this. We're going to throw your clients in jail. We're going to throw their principals in jail, has literally arrived in someone American's home, right? My home, and also the homes of my clients who receive these letters from foreign governments. And the effect of receiving those threats in their homes is to chill American speech. It causes fear, it causes anxiety, and it causes, in a lot of cases, companies that receive these change their behavior, right? They say, listen, we've been threatened. Ofcom, which is the UK's censor, has sent at least 197 demands into the United States in the last 18 months. And of those 197, I know this not because there's a document which says it, because I represent all the clients who did it, only 4 were refused in a public fashion. Only 4, right? So that's a 98% compliance rate that Ofcom has gotten simply by threatening American citizens in the free exercise of their constitutional rights. Simply by sending an email, right, over the wire, you must do what we say. They throw their hands up and say, well, we're not sure, right, what their enforcement powers are. We don't really want to fight here. So the problem is that these foreign governments are getting away with it. They're threatening Americans. Americans are rolling over. Very few of them fight back. And that changes the information environment in the United States to start to look like the information environment in the foreign country. In effect, what's happening is free speech in America is being restricted because foreign governments are threatening American citizens. So we need to figure out a way to stop that. And that requires 2 things. One, a novel approach to thinking about what causes of action we can bring. We need an actual new cause of action. This isn't a tort in the United States. And it's not a crime in the United States. And the second thing is these sovereign immunity doctrines, which used to apply to ambassadors and warships and other things, require a carve out. And it's not the first time, right? So we reinvented our sovereign immunity doctrines when when the country created the Foreign Sovereign Immunities Act in the 70s. But over time, that's been whittled away for things like state sponsorship of terrorism, right? JASTA and rules like that. Now, what's happened is the internet then happened, right? And now what's happening is foreign governments are using the internet to interfere with Americans' constitutional rights. And when an American then goes to court to vindicate those constitutional rights, the foreign government says, listen, your sovereign immunity doctrine protects us from the jurisdiction of your courts. So on the one hand, the foreign government is saying foreign law applies in the United States. And on the other hand, they say, well, oh, by the way, even though our laws apply in the United States, when you go to an American court to vindicate your rights and hold us accountable for the exercise of that power in the United States, we're immune, right? Which is a completely lawless situation, which is not consistent with our Constitution.
And that's not a hypothetical either. The example you gave of a foreign government or for a regulatory agency in a foreign government making those arguments in American courts, that's what you've seen in the 4chan cases.
Yeah, it happened. It's happened in the 4chan case. We've argued, I'm obviously somewhat limited in what I can say because I'm counsel in the case and it's live litigation. But our argument is that Ofcom is coming to the United States and charging American companies fees, and that's commercial activity and thus fits within one of the existing jurisdictional exceptions. That case is fully briefed and we're waiting for Judge Contreras to rule in the DDC. So I'm not going to say more about that. But also Brazil has done the same thing in a case that was brought by Trump Media and Technology Group and Rumble, which is a video sharing platform, because Brazil served them with censorship orders. And they turned around and they sued Brazil. Specifically, they sued Judge Alexander de Moraes, who issued the order. And then Brazil has intervened in the case and also argued that it, too, is immune from the sovereign immunity of American courts. So every foreign country is currently operating under the assumption that they can do this and it's going to be entirely free of consequence because our courts will look at what Congress has said and say, listen, our hands are tied because even though these orders are coming in, we don't have the jurisdiction, because when you raise sovereign immunity, right, it's a jurisdictional question, right? And it's a subject matter jurisdiction question. So it's a Rule 12b1 motion. Boom, let's kick this thing out, right? So it's a threshold issue. If they succeed on sovereign immunity, the case ends. And so we think, and they know this, right? They know that if they succeed on sovereign immunity, the case ends, which means that it's not worth Americans' time in a lot of cases for big corporations to bring the lawsuit. And it's not worth, it's not worth its fight, right? And the foreign government says, well, our program is politically very valuable to us, so we're willing to fight the odd case here and there in order to try to ensure that the program succeeds. So in response to that, we need a counter regime here in the United States. We need our own program that will ensure that if they cross our border with these orders, that they're not going to have a nice time. And that's what GRANITE is designed to do.
And let's talk about how the GRANITE Act does it. I know there's sort of two parts of it. There's the sword and then there's the shield.
Yep.
Could you talk about what the components are, how it protects Americans?
Yeah, so the shield is pretty simple, and it's actually derived and inspired by the Speech Act, which was a law passed. If you're in Congress and you're watching this, the Speech Act was passed by both houses by voice vote and signed into law by President Obama. This should not be a partisan issue. But it was inspired by the Speech Act, and it confirms that foreign judgments are not enforceable in the United States. But the other thing it does, which is slightly different from the Speech Act, is that it confirms that fines, orders, or demands are also not enforceable in the United States. And the reason for this is because foreign censorship regimes don't usually operate through courts. They operate through administrative fiat and executive branch agencies. And the executive branch agencies are purporting that those demands are binding at the moment that they are served, and they purport to serve those things by email, which of course doesn't work in the United States. So they've created this whole, this scary regime where they can just send an American a message, and from their point of view, the American has to obey and has been validly served. Our purpose is to deter those notices from being sent, because obviously, as we've seen from that 197 notices and only 4 refusals, it's the transmission of the notice which is creating the censorship, right? It usually doesn't proceed to court proceedings or something else. So it's a very Speech Act style shield, but it's also designed to cover basically any foreign demand to censor yourself in a way that would violate the Constitution, if it were recognized here. The second part of it is a private right of action. So what you can do is you can sue the foreign censor, and you can drag them before an American court, with, of course, a sovereign immunity exception, which has been baked in that would allow that action to succeed. And so you can drag them into an American court and ask an Article 3 judge for a declaration that the foreign censorship order, demand, fine, etc., is void. Now, in the original proposal that we proposed back in February, which is kind of in Wyoming, which was sort of a blueprint, we proposed sort of a turbo damages language. I called it thermonuclear damages language, where the damages that you could retrieve would be equal to the amount of the threatened fine. So if they threatened Facebook with a 10% global revenue fine, Facebook could go after them for a $16 billion judgment, right? So that is like the extreme version. And I'm kind of an extreme guy sometimes. So that's why we did that. But we thought that was an appropriate remedy. Representative Raleigh has not done that, and I don't think it's all bad, right? I think actually it's probably a good idea, because if you have damages, you have to do more extensive surgery on foreign sovereign immunity doctrine, and it's far more radical in terms of the types of changes that you'll have to American law. And as a consequence, it could create diplomatic headaches. It could have unforeseen consequences. So what he's proposed is that you go and get a declaration from an American court. And the question is, well, okay, fine, you get a court declaration. What does that do? What we've observed from the Ofcom case is that, one, foreign censors really don't like it when you drag them in front of an American judge and you characterize their conduct as censorship, because it makes them look bad politically at home. Two, there are associated costs and expenses with that, which, I don't know what their litigation costs are, but, I would imagine it's certainly higher than zero. That would affect their ability to then safely send these notices, because every time they send the email, they know, okay, well, if we send this, the answer might be a lawsuit in an American court. So it attaches a cost to their actions, which wasn't present before. And the third thing is, another thing that we learned about Ofcom, which is the UK's censor, is that they got hit with a FOIA request by a free speech activist named Daniel Liu, asking them how much time they spent on the case, right, on the enforcement action against my client, 4chan. And it was revealed that it was somewhere in the neighborhood. They didn't disclose exact numbers, and they described them in a way that made it seem very small. They said it's 0.9 to 2.6 full-time full-time in 9 months, right? But if you extrapolate what full-time means, right, that's one person, 8 hours a day for a month. We estimate it's somewhere between 2,000 and 2,800 hours in total, right? Which, and on law firm rates would be $2.8 million, $3 million, something like that, that they've spent in terms of raw labor time on this enforcement action. And what they got in response, right, was zero compliance, one federal lawsuit, and 4 pictures of hamsters that took me exactly 30 minutes to produce. So by creating this deterrent structure on the other side, the other foreign governments, they have money, but it's not unlimited, and their censorship agencies are not where they spend most of it. So by creating this deterrent structure on our side, where they know that entering the U.S. is going to lead to costs, that's the kind of thing which we think will make the notices stop. And again, it's the threat of censoring American speech, which has been shown to be the way that most of the censorship is occurring, right? They say, we're threatening you with this, and then people clam up and they surrender their rights. And so if we can create enough deterrent on our end to say, listen, you come over here, right? And it's that Far Side cartoon, right? How Mother Nature says, do not touch, right? And it shows a cat, arching its back, and a pufferfish puffing out its spikes, and then a guy wearing a trench coat, like a duck, like water toy, holding a bazooka, wearing a hat sideways, right? I don't know if you've seen that one.
No, I haven't seen. I'll put it up on the screen for people.
Basically, it's a way that we can communicate to them, how nature says do not touch. You should clip that and put it in. But essentially, that's what we're trying to do. We're trying to say, listen, you can do it, right? You're a sovereign. Do whatever you want. You come over here, there will be consequences for that. And those consequences will be consequences that you haven't seen before. So if you want cooperation from the United States, kindly use the regular channels, the MLAT channel, diplomatic channels, coordination between law enforcement agencies, that sort of thing, to do legitimate things in the United States that are properly the subject of dual jurisdiction cooperation, namely like serious crime, which satisfies the dual criminality principle. And so that is unaffected by this, right? This is just about speech. And so that's what GRANITE is. That's what GRANITE is designed to do.
Yeah, there's the sword and the shield component that you outlined there, which are so important. So this is the first instance of it being introduced in a federal, federally. It's also been introduced in states before. Could you talk about where things are at a high level? I know there's a lot that you can't say, but what happens next, and how does it work when you have some state ones and some federal ones?
So the states, we'll start with the federal. So on the federal level, I know of 3, including Representative Rowley's. I'm not going to say what the other ones are. So it's just a question of seeing what legislators come up with and what they propose. So that's federal. At the state level, we tried to get a bill passed in Wyoming last year. And we had damages language, but of course there's sovereign immunity, which is a federal issue. So sovereign immunities, obviously federal supremacy is a question. So that got through the House of Representatives 46-12, which is not close. And then it stalled in the Senate because it was a very, very short budget session, and we couldn't get it over the line in time. That's coming back next year as a shield only bill, because basically all of the questions that came up at state level were about federal supremacy. Are we interfering with the Federal Sovereign Immunities Act or Federal Foreign Sovereign Immunities Act? Does this affect, are there Commerce Clause issues? Are there foreign relations issues? And there wasn't enough time to consider them. So we figured, you know what? We didn't know that there was going to be a federal bill until very recently. And so as a consequence, the V2 effort in Wyoming was pared back to a, shield only. This is something which confirms that these orders aren't enforceable here. And it's something which is within the competence of the state legislature to legislate without requiring federal consent. New Hampshire is going to be filing a bill. It depends on whether Rep. Calvin Beaulieu has said he's going to introduce that. That follows the form of the ALEC GRANITE Act. So ALEC is the American Legislative Exchange Council. They write model bills, which have a very strange habit of getting enacted in dozens of states after it becomes a model bill. And so they propose the ALEC GRANITE Act, which is a shield-only bill for the states. And New Hampshire will, as I understand it, be following the ALEC template with their proposal. There's another bill in a very relevant state for corporate formations that I'm not going to mention about that I've seen in draft. So you can read between the lines. But I'm not going to mention that one. I'm told there might be some movement in the U.S. Senate. Senator Eric Schmidt has said in public that he's planning on introducing a shield bill of some description at some point. He hasn't done so yet, but that's all TBD. So, there are a bunch of different efforts. The key thing is that GRANITE is not a single bill, right? It's a method And what we found is that method is something that legislators and people who advise legislators really, really like. Net Choice has come out in favor of Granite. They did so just this morning. So I think what we've done is we've stumbled upon a template that most American legislators think can work. And there's enough drafting out there that it's really easy for a legislator in Arizona or California or in Washington at this point to just pull some language off the shelf, make some modifications, according to what they think, their bill should say, what's important to them. And then they can introduce a shield, which has been through many, many different rounds at this point of review. And so this federal bill, it's really tight. It's really clean. It's very elegant. It just says, listen, Americans on American soil get to be American when they're on the internet. And foreigners who come to America to use the internet get to benefit from the fact that American infrastructure is governed by American law. So it's not a radical proposition. It kind of winds back the clock to sort of, 2015 or so. So when basically no foreign government had attempted to regulate the American internet from afar. And, things are pretty good back in 2015 on the internet. There are lots of corny memes and things like that. So I think that, if this is enacted, it'll be really, really good for American speech, and it'll be really good for speech around the world.
The GRANITE Act, small and mighty like the hamsters that have been sent over to Ofcom. Preston, thanks so much for all the work that you're doing. I think it's really, really important to the future of free speech, the future of the open internet. And on behalf of everyone who's listening, thanks for joining me.
Thank you for having me. It's always a pleasure.
That was a really, really interesting conversation. I really enjoyed learning from Preston. If you want to learn more about the GRANITE Act or read his blog post about it, I'll put a link in the show notes for you below to check that out. It is very short. There also, if you've been watching the video version, you've been able to follow along and see actual text from the bill itself. If you did enjoy this, please share it with a friend or an enemy. It could be a good opportunity to get back on their good side. Thanks for joining me. And thank you again to the other sponsors of this episode. I mentioned Altitude, the stablecoin payments platform, but there's also the law firm Cahill, Gordon, and Reindel. If you're curious about how anything we discussed here applies to your situation, you can contact Lewis Cohen and the team there. There's also the Hyperliquid Policy Center and the Solana Policy Institute, two organizations that do really important work in Washington and in the rest of the US to bring important products and important understanding about them to the politicians in America. And I think a lot of that work is really important. So thank you to all of them for supporting this and for the work that they do as well. Next episode will be with a conversation with Commissioner Hester Peirce about Reg Crypto. See you then. And yes, I'm wearing a tie.